G'day there guys, it's your Aussie Hubby Markee, back at it again with another r/legal advice video. Now, if you love me as much as I love you, then you know what to do. I want you to mosey on over to that old like button and tackle it like Crocodile Dundee. Maybe even chuck an Aussie flag down in the comments. Now with that said, I want you to sit back, relax, chuck a prawn on the barbie, and get ready for some bloody legal advice. Now our first story today is by user Matalol, titled, "Neighbours stupidly caused themselves to be landlocked. Are we going to be legally required to share our private road?" Here is a picture of the land area. Our state is Minnesota. The vertical grey strip on the left side of the image is the public main road. I own the land in pink. Our private road we use to access it is entirely on our land, surrounded by pink, denoted by our road. It has a locked gate and the sides of our land that are against roads are fenced. We have remotes for it, or can open and close it from our house. The neighbour used to own the land in blue and purple, but sold the purple land to someone else a couple of weeks ago. They accessed their property by a gravel road on the purple land before, but the person who owns it now is planning on getting rid of that gravel road. Apparently, when they sold the land, they were assuming they could start using our private driveway instead. They didn't actually check with us first. They have effectively landlocked themselves, ultimately. The neighbours want to use our road, denoted in grey, and make a gravel road from our road onto their property in blue that they still own. We have had some heated discussions about it, and things went downhill fast. They say that by not giving them access to our private road, we are infringing on their rights of their property ownership. Now they are threatening to sue us. If they sue us, is it likely that a judge would require us to let them use our road? Do we need to lawyer up? Thanks. Going by general principles of easement and property transfers. When Blue severed his parcel into blue and purple, he should have reserved an easement across purple. You have no legal relationship with Blue and no duty to provide Blue with access. That Blue did not check with you for permission first is not your problem. An easement is a burden on title. A parcel of land carrying an easement is at least in theory, reduced in value by some extent. Thus, a neighbouring landowner with whom you have no legal relationship cannot impose a burden on your land. Something you do has given rise to the easement. I cannot imagine your neighbour having any recourse against you whatsoever. If he were the purple guy and sold off the blue portion to a third party, that party could claim an easement by implication, or by necessity against purple. Court assumes that the purchaser wouldn't have made the purchase without assuming he'd have access. It's a little different in Blue's case. He may or may not be able to claim an easement against purple. Against you, can't see it. Don't worry about an attorney unless he sues you. If you decide to allow him access or reach some kind of settlement, make sure to use a written lease that shows that he has permission to use the access. You want it in writing. He may have no intention of attempting to gain an easement by prescription, and your state's laws may not allow it under these conditions. But a writing is cheap to do and defeats any claim of easement by prescription. Prescriptive easement is when you are unaware of or ignore your neighbour using your land for a long period of time, such that he can later claim a right to use it indefinitely. Giving explicit permission to use the land defeats this, since it shows you are aware of and not ignoring your rights. Google Minnesota easement by necessity, and look at the top unsponsored link. I would paste the link, but my browser is making it unintelligible. Anyway, it's a link to a PDF that appears to discuss easements in Minnesota. I can't vouch for it since I'm not barred in Minnesota, but it appears to cover the ground. The burden on the title part is particularly compelling. It's quite likely the neighbours deliberately sold the land without an easement for their own access, not wanting to reduce the sale value of the land, which it would because the new owners want to use the whole of their land for livestock. You can't have your cake and eat it too. Maximize the sellable value of your own land and reduce that of OP. The courts are going to be very skeptical. Oh, good point. Easements are an equitable remedy, and it could be argued that Blue has unclean hands, or at least that he benefits from his own mistake in the form of a better selling price to Purple. If the judge grants Blue an easement across Purple's land, it would be interesting to see what Purple does, and whether that would be enough to rescind the sale. Someone used equitable remedy and unclean hands in a real-world legal situation. If anyone needs me, I'll be hiding my law burner behind my desk. Thanks. I found information on easements, but not the specific necessity ones. I will read up on that. Unfortunately, someone here is saying that it's likely a judge would order the easement on our land because we already have a road. I can't say this would save your butt, but if there is in fact a gravel road across Purple's property at this moment, go get pictures of it showing that Blue's most reasonable access would be that gravel road. An easement should go where there was unity of title. That is, where the property was owned by one person, that's the unity of title part. Then it is split. It should go across the part that was sold, and not where it would burden an innocent third party, your interests. It is not your problem that Purple wants to fence off his property, that's between him and Blue, at least the way I see it. A friend actually suggested the exact same thing. We took pictures from several angles with a newspaper in the picture, so they can't say those pictures were old. And now, update, my neighbors caused themselves to be landlocked, now the sheriff wants me to let them use my road. So I posted that post last week. To make a long story short, my neighbors sold their part of their land in a way that left them landlocked because they assumed I would let them access their property via my road, which is gated and locked at all times. I got a lawyer and I met with him. We hashed out a plan and I was feeling pretty good about everything. Yesterday, Sunday, around noon, the Purple landowners finished fencing in their property. My neighbors came home at about 3 PM and rang at my gate several times. I was advised by you guys, as well as my lawyer, to not let them in my gate even once, as that would set a precedent of them being allowed to use it, so I ignored the ringing. Eventually, the husband got out of the car and walked around to the side of my property, which is not fenced in. He used that to get to my house and knocked on the door. I answered and told him I would not allow him to use my gate and to leave my property. He told me he wouldn't leave until I opened the gate, so his wife could drive the car through. I said I would not do so and threatened to call the police. He walked left and went back to the car. They then started ringing the gate again. I looked out the window and they had a police officer with them. I went to the gate and informed the police officer that this is my property and I will not allow them to drive on it. I said that they have no legal right to access my property. Then I walked back to my house. After a couple of minutes, the police officer walked around to get onto my land and to the house and knocked at the door. He said that because their land is landlocked, I need to allow them to use my road until another solution can be figured out, and I can't just deny them access to their property. I called my lawyer, who spoke with the police officer on the phone. The police officer acknowledged that he cannot force me to let them drive on my property, but that he strongly encourages me to work this out with my neighbors in a civil manner. He left. The neighbors left their car in front of my gate, walked around the unfenced part of my land, walked across my yard and onto their own property. I called my lawyer. We reported them for trespassing today. They left their car there until about 10 AM this morning. Tonight I was visited by the sheriff. He told me, very short and sweet, that I cannot deny my neighbors access to their property via an established road. He said I better not get another call. From this point forward, you will allow them to get to and from their property and will not lock them out or in. Then he walked away, and I called the lawyer. I am meeting with the lawyer in the morning. I am planning to ask her the following questions. 1. Is there a point where I should give in to a police officer's request that I let them use my road? 2. If they block my gate again, can I have their car towed? The way they parked it, I would not have been able to leave my property via the gate. They were parked on my land at the time, not on the public road. If anyone has any thoughts on these, I am all ears. Thank you. Thank you so much for keeping us updated. This case is fascinating to me. He told me very short and sweet that I cannot deny my neighbors access to their property via an established road. Your driveway is not an established road. However, if you start letting them use it, it will become an established road. You're going to have to be stubborn up against the cop. He's leading you in the wrong direction, and it could be detrimental to you. Ironically, the road he previously used on Purple Guy's property is an established road, and the cop should be telling that guy he couldn't block his access. I actually pointed that out to the cop. He said that it's difficult because to use Purple's road, they would have to ask Purple to take down their fence and secure their animals out of the car's path. Fences aren't intended to come down to let cars pass, but gates are intended to open to let cars pass. You may want to consider putting up a fence. If it works for Purple, it'll work for you. My lawyer said that we might consider it in the future, but to not do it right now. She said that while Purple had documented plans to use the land in such a way that necessitated a fence, it will be obvious that my recent fence being put up is in light of this whole issue, and that a court might frown upon me making those kinds of changes in the middle of a dispute. What if you get a goat? Then you could get a fence and say it's because you have to protect your goat. And you'd have a goat! Get two, or else that damn thing will cry and scream. Goats need buddies after all. We have special needs kids. Those are even better than goats for that justification. In all seriousness, they are the biggest reason this is an issue for me. My kids deserve a safe and secure environment. I do not trust the neighbors or their guests to maintain a safe, secure environment for my kids. When you talk to your lawyer, you might ask about going to court to get some sort of preemptive injunction, /restraining order, /no trespassing, /they can't drive on your land order from a judge. If you've got that in writing from a judge and are asking the police sheriff to enforce it, that may help. It sounds like to me the sheriff is mistaking your private driveway for an established common road. Thanks for the update and good luck. +1, I would love to know what the neighbors have told the police /sheriff, because it sounds like someone has informed them that it's an established common road. No, it sounds like the sheriff doesn't want to keep driving out there because of the blue neighbors, so he started throwing legal sounding words. Don't listen, OP. And our last one on this matter. Update. My neighbors caused themselves to be landlocked. I posted here. It's resolved now. So I posted here for advice a while back and received some excellent, some funny, and some conflicting advice from all of you. The overwhelming advice was to get a lawyer, which I did. I explained the situation and that I had posted here, as well as the many topics you all prompted me to read upon, which was very helpful. While my lawyer seemed pleased with your advice to me, he also urged me to immediately stop publicly posting about the situation, which I did, and which I see from my many messages has disappointed all of you. First things first, everything worked out in my favor. My wife was upset by the entire situation and especially concerned with our children, and she got involved as well. She spoke with some friends who were able to get in touch with the local city council. They could not explicitly do anything directly to help us, but did get in touch with some of the right people to discuss our situation. One of the most important results from those connections was learning that the sheriff, who we spoke to, was actually a deputy acting on the sheriff's behalf. We were able to meet with the actual sheriff. He did agree that we should be more open to compromise, but was much more willing to admit that we had no immediate legal reason to do so, and no interest in forcing us to. My lawyer made a key point of the fact, I use the term loosely, that if the neighbors require an easement to access their land, they should do so with the land they sold, and not with unrelated land. After a lot of back and forth, but no court proceedings, luckily, with the other party, their attention was refocused on the buyer of their land. Funny enough, it's a small world, and I ended up meeting with the buyer who was in my lawyer's office for a consultation with one of his partners. He ended up needing to get a different lawyer, since I already had a lawyer from the firm, as I understand it, but we kept in contact to some extent. Now, some speculation. We believe that the reason the neighbors didn't bother us for a while was their finances. Their lawyer was happy to keep pushing as long as he was getting paid, but when money ran dry, he lost interest. Due, we believe, to those financial problems as well as their inability to find a quick solution, the neighbors ultimately moved into town and lived with family there for several months. The neighbor on the other side gave them one-time access with the moving truck. Their lawyer had been showing up with them but was gone at that time, which is another reason I suspect major money issues. In the fall, the situation picked up again, with contact from a new lawyer this time. This new lawyer requested a meeting with us, and our lawyer, of course. He requested that we consider buying their property to resolve the issue. We initially said no. They offered it to the owner on the other side. They said no. They sweetened the pot. Eventually, the price was right, and my wife and I developed an interest in more land. We discussed terms, then decided against it. They went a little cheaper again. We purchased their land. I nearly posted an update once the purchase was complete, but there was an additional interesting detail that came out of the woodwork and brought new legal questions. The neighbours had used their land and home as collateral for an informal loan, and the person who lent to them wanted the property when they failed to repay him. He came after us. The outcome of this was that they are the ones who failed their end of the contract, so his problem was with their neighbours, not with us. This is definitely a sideline from the original situation, but caused a delay in my ability to update. As of today, my wife and I are out a substantial amount of money due to legal fees, which it turned out was not worth going after from the neighbours. There is also bad news in that home on the property, which was essentially worth even less than what we thought, and there were major issues beyond the land itself. Septic tank failure, leaking oil tank. Those expenses were slightly mitigated by insurance, but we are out a good sum. We also had a hard time combining the lots, which was legally desirable to build anything that straddled the two property lines. However, the plots are now combined into one large plot. The good thing is that the neighbours are no longer an issue for us, and by this summer, their property should be in good shape to use for a new project of our own. On one hand, I will say this. The little chunk of land was definitely not worth the time and stress involved in this process, nor the money. However, the outcome was positive for our family, for which there is no dollar value, and it's all over with now. My sincere thanks to everyone who offered advice. There are far too many of you to thank individually, but please know that I appreciated everyone's contributions, and I hope you are all still around to read my much delayed resolution. And with that one finished, because I know you guys love it when I finish stories, on to our next one by Gingy Frost. Coworker thought I said something that I didn't, and it's grounds for firing due to it being sexual harassment. So, long story short, coworker complained about something I said, which I didn't say in the slightest, but because of what was heard by coworker, it's considered sexual harassment. Of course, I have no idea who heard this, what day it was, or anything, because they want to protect said coworker. Anyway, my manager told me the story, which sounds very unlike me to say in public, and at work as well. Just wondering if I should wait it out after told my side of the story. Hi, HR here. Your company should do an investigation into this incident before moving forward with any repercussions. Update your resume just in case, but if your coworker can't provide witnesses to what they said you did, it's a he said she said situation, and your known behavior should speak for itself. Best of luck. What did you supposedly say, and to whom? Something about someone's chest size, and I don't even know who I would have even said that to. If it's a single incident and possibly a mistake, it will probably blow over as long as you don't blow it up into a bigger deal than it is. Companies usually prefer things to settle down. If you become super argumentative right away though, people's brains will go into, where's there's smoke, there's fire mode, and it will likely escalate. If you think one of your coworkers actually has it out for you though, that's a different situation, and in that case, looking for a new place to work might be wise. Honestly, I don't think anyone would have a hard-on to get me fired. I come in almost 20 to 30 minutes early, get ready to clock in 10 minutes early. I try my best to be friendly and helpful, but you never know. Could be someone scared of friendly on-time co-workers. And edit. Thanks everyone for all the support. Also, just a little update. Manager did me a huge solid and had my back hardcore, and no one is getting fired. So there's your resolution. Manager fixed it. End of story. Alright guys, and our next post is by user HelpRequired1982. New roommate is actually a family and has taken over our apartment, eating my food, dictating what I can and can't do. Now they are being openly hostile towards me, and I can't take this. Landlord won't let me out of the lease, police say it is a civil issue. So I am renting a room in Toronto for university. The apartment is shared between 3 of us. I have a lease for my room and nothing else. I moved into this place in January, and up until May it was just me and the other roommate. In April, landlord told us a couple, not one person, would be moving into the empty room. I was fine with it because I didn't care that much. When they moved in, it became instantly apparent it was not just a couple. It was a couple, 2 kids, and another man. We immediately told our landlord, and the couple would keep reiterating that they are allowed to have guests. Landlord has told them no, they cannot do this, as it is not safe as the unit is over capacity, but they have just ignored him. Those guests have now been there for over a month. Our landlord is trying to evict them through the LTB, but it has left me and my roommate in an extremely crappy situation. On top of this, our landlord has basically told us if he lets us either of us out of the lease, then the family will completely take over the entire apartment, and he won't be able to re-rent it. The family eats my food. I can't leave anything outside of my locked room. Last week, the father and the mother got into a huge screaming argument that I cannot understand, which led to a domestic abuse incident which terrified me. My roommate called the police, and the father was removed. He came back the next day, and they have been arguing and screaming every other night. Last night, I invited a friend back to my place, only for the father to start screaming and accusing me of basically being a tramp, and then trying forcibly to force my friend out of the apartment before I called the police. The police came, and I explained the situation, and after a bunch of back and forth, he finally let my friend enter the apartment. I broke down when explaining the whole situation to the police officer, and while he empathized with me, he told me it was a domestic issue. I am sick of this. I want out now. My roommate's lease is up at the end of August, but is planning to just move into her boyfriend's and just eat the cost. I don't have that luxury, unfortunately, and I am terrified of how this is going to go when she is gone. How can I break my lease? What are the penalties of breaking my lease? I offered my landlord 2 months of rent, all I can afford, and he did not take it. I'd be willing to bet you can get out of the lease on the grounds that the landlord isn't keeping up his end, and you are denied quiet enjoyment and are also in fear due to the domestic violence issue. You could also look into getting a protective order against the abusive man. Collect police reports every time he gets out of hand. Thanks. Do you know how that works exactly? Is this something I need to go to the LTB for? My roommate is out of here on Friday morning, and I don't want to deal with them when she leaves. It may not be that simple. Your landlord is already doing the single most urgent and effective thing they can do to bring your unruly flatmate under control by filing to evict them. The LTB does hold that your landlord's duty to protect your reasonable enjoyment extends to evicting tenants who present a chronic hazard, but not to the point that the LTB expects miracles from your landlord. Ontario's process for terminating a lease due to domestic abuse also does not support fear of such abuse, only actual domestic violence or sexual abuse towards yourself or towards a child residing with you, likely interpreted to mean under your care, not merely living in the same unit. It is possible that their actions towards you rise to that level, but not guaranteed, and the penalties for filing the termination paperwork under false pretenses are steep. There is no formal process for breaking your lease as such. Terminating your lease is a remedy the LTB can order, but for the same reasons, it'll take months for the eviction to happen. It'll also take the LTB months to hear a complaint against your landlord, and as above, your landlord may already be taking all reasonable steps. If you want to break your lease, you can. The lack of a formal process doesn't stop you from moving out and ceasing to pay, but you have no formal protection from legal action to recover unpaid rent while the unit is vacant if you do so. One approach you could take that might help is to give your landlord reasonable notice that you are unable to tolerate these conditions and will be moving out, and simultaneously file a T2 form with the landlord and tenant board anyways, asking that your lease be terminated on the date you intended to move out. Then move out as promised, even if your hearing hasn't yet occurred. The LTB can order your lease terminated retroactively if necessary, and acting reasonably towards your landlord will go a long ways to help your side. Another approach you could take would be to take advantage of the province's right to assign your tenancy. If you find a specific assignee, in good faith, no fair picking the new occupants that your landlord is already evicting, and request in writing permission to assign your lease, either your landlord will assent, problem solved, you move out, they take over, or refuse. If they refuse, you can give your landlord Form N9 anytime within the next 30 days, giving 30 days notice that you are ending your tenancy. A third approach might be to call 311 and have a bylaw inspector come out and issue a formal notice to your landlord that the unit is over its legal occupancy limit. That will put your landlord on a short timeline to resolve the issue. The city can order the occupants out immediately, with, I believe, 72 hours notice if the issue is not resolved, which would frustrate your lease and give you good grounds to stop paying and walk away unless your landlord provides alternate accommodations. Deliberately lining yourself up to get kicked out by the city means you should be prepared to pack and leave as well, but you're at that point anyways. A fourth approach might be to seek a peace bond against the new occupants, citing the ongoing issues you're having with petty theft and your reasonable fears of domestic violence. A peace bond issued by the Justice of the Peace is a binding court order, and comes with criminal consequence if violated. They are fairly flexible, and while a peace bond not to interfere with you in your home and to cease stealing your food might seem petty, it would put this back into territory the police can help you with. Finally, you can just cut and run, and take the risk of being sued for the outstanding rent. Your landlord's only recourse once you've returned possession is through the small claims court, which is expensive, around $200 to file, and slow. 6 months is normal. It also relies on them knowing where you've moved to so that they can have you served. And while I don't recommend dodging service as a way of getting out of bills, mainly because it doesn't work, nothing says you have to leave a forwarding address either, or otherwise make the plaintiff's life easy. If you leave, they may decide they have enough on their plate dealing with this tenant and do not have the time or attention to sue you. The statute of limitations on a claim on this nature is 2 years, so you won't be safe from legal action for a while, but realistically, if they don't come after you quickly, they may not be able to find you. And that's the resolution to this one. I hope you guys enjoyed this episode of Legal Advice today. I hope you guys found that useful. That's a lot of information that could personally help you if you find yourself in a situation like this. I know I haven't posted much today, and that's apologies for me. I've been playing too much Mountain Blade Warband. I'm thinking of streaming it so you guys can see what I'm up to. It would give me a reason to actually have you guys included in my life outside of the YouTube channel. Anyway guys, if you've enjoyed this today, please do leave me a thumbs up on the video. Tell me what you thought about all this legal advice today. I love your faces, and I will see you in the next episode. Bye.